President, and I rise today to ask for disapproval to stop the National Labor Relations Board's ambush election rule. This rule that I'm objecting to was rushed into place by a National Labor Relations Board that's bound and determined to stack the odds against the American employees and to put employers and to put employees in an unfair situation. Despite the fact that unemployment has remained above 8% for the past 3 years, and small business growth is the most important factor in reversing the lackluster trend, the National Labor Relations Board has chosen to impose new rules to aid big labor at the expense of employees, particularly small business employers, and the jobs they would create. If the Senate does not act now to stop this rule by passing my resolution, it'll go into effect on Monday, April 30th, just 10 months after it was first proposed. The changes that are being made are going to be a big surprise for the employers and employees that get caught in this net, particularly, as I mentioned, the small employers that do not have the human resource departments or the in-house counsel. I would expect that we, elected representatives of the people, are going to face a lot of questions about what we did to stop this blatant effort to stack the odds in big labor's favor. And we will be asked. This rule will shift the law significantly in favor of big labor. Let me take a moment to explain. Under current practice, there's a 25-day waiting period between the setting of an election by a hearing officer and the actual secret ballot election. Employers can use this time to familiarize themselves with the requirements and restrictions of the law. This is very important because there are many ways that an unknowledgeable employer with the best intentions could make a misstep that would be heavily penalized by the National Labor Relations Board. Employers also use the time to communicate with their employees about the decision they are making and correct misstatements and falsehoods that they may be hearing from union organizers. Parties also use this time to seek review of a decision made by a hearing officer or a National Labor Relations Board regional director. Under the new law, the new regulation, the 25-day waiting period is abolished, and employers may face an election in as few as 10 days. Is it fair to the employees to only have 10 days to learn how this will affect his or her life and how much his or her hard-earned money this will cost? Under current law, both parties are able to raise issues about the election at a pre-election hearing, covering such issues as which employees should be included in the bargaining unit and whether particular employees are actually supervisors. Under the new regulation, parties will be barred from raising these questions until after the election. Employees will be forced to vote without knowing which other employees will actually be in the bargaining unit with them. This is important information that weighs heavily in most employees' vote. Additionally, because of the National Labor Relations Board's decision to allow micro units, like specialty health care unions, the unions will essentially be granted any bargaining unit they design, and employers will have a very limited time to weigh in. Under current law, when either party raises pre-election issues, they're allowed to submit evidence and testimony and file post-hearing briefs for the hearing officer to consider, and have 14 days in which to appeal decisions made with respect to that election. Under the new regulation, a hearing officer is given the broad discretion to bar all evidence and testimony unrelated to the question of representation and all post-election briefs, and no appeals or requests for stays are allowed. This can be quite a disadvantage for employees as well. What this all adds up to is an extremely small window of time from filing a petition to the actual election. Little opportunity for employers to learn their rights or communicate with employees their rights. And less opportunity for employees to research the unions and the ramifications of forming a union. The NLRB is ensuring that the odds are stacked against employees and businesses. This vote's an opportunity to tell the NLRB to reverse course. If we pass this resolution, as I hope we will, the Senate will not be the only branch of government telling the NLRB it's off track. Last month, a District of Columbia federal court told the NLRB that several provisions of its notice posting regulation were well exceeding their authority and struck them down. This was a judge appointed by President Obama. 2 weeks ago, another federal court, this time in South Carolina, also ruled against the NLRB. It found that the entire notice posting regulation violated congressional intent. Following up on these two rulings, the D.C. Court of Appeals just stayed the entire rule until appeals are completed. The court in that case was frustrated that the NLRB did not postpone the rule itself, given the multiple negative treatments in the courts. Unfortunately, that reckless sense of blind mission is consistent with this administration's NLRB. It's kind of like Thelma and Louise driving off a cliff. Well, Mr. President, I, for one, do not want to see the NLRB drive our economy off a cliff. I hope this resolution will pull them back and encourage them to focus on their statutory mission. The National Labor Relations Board enforces the National Labor Relations Act, which is a carefully balanced law that protects the rights of employees to join or not join a union, and also protects the right of employers to free speech and unrestricted flow of commerce. Since it was enacted in 1935, changes to this statute have been rare. When they have occurred, it's been the result of careful negotiations with stakeholders. This change is one-sided and super quick, an ambush to set up ambush elections. National Labor Relations Board is not an agency that typically issues regulations. Listen to this. In fact, over 75 years, the National Labor Relations Board has finalized only 3 regulations through formal rulemaking, 2 of which occurred last year. Let me repeat that. In over 75 years, National Labor Relations Board has finalized only 3 regulations through formal rulemaking, and 2 of them occurred just last year. This current National Labor Relations Board. As I mentioned, one of those was already struck down by one court and stayed by another. Most of the questions that come up under the law are handled through decisions of the board. Board decisions often do change the enforcement of the law significantly, but they're issued in response to the actual dispute and question of law. In contrast, the ambush election is not a response to a real problem, because the current election process for certifying whether employees want to form a union is not broken. This rule was not carefully negotiated by stakeholders. Instead, it was rushed into place in over just 6 months, despite the fact that it drew over 65,000 comments in the 2-month period after it was first proposed. Labor law history provides an interesting contrast to this rushed regulatory approach. In the late 1950s, Congress became concerned about undemocratic practices, labor racketeering, and mob influence in certain labor unions. Excuse me. To address this, the Senate created a special committee, the Select Committee on Improper Activities in the Labor or Management Field. That operated for 3 years and heard more than 1,500 witnesses over 270 days of hearings. Based upon their investigations, the Senate negotiated and passed legislation to protect the rights of rank-and-file union members and employers. The legislation is known as the Landrum-Griffin Act. The issue of how long a period of time there should be between the request for an election and the actual election came up during those negotiations. My colleagues may be surprised to learn that it was Senator John F. Kennedy who argued vigorously for a 30-day waiting period prior to the election. As he said, quote, "There should be at least a 30-day interval between the request for an election and the holding of an election in which both parties can present their viewpoints. The 30-day waiting period is an additional safeguard against rushing employees into an election where they are unfamiliar with the issues." End quote, by John F. Kennedy. Fairness to the employees, that's what Senator John F. Kennedy was talking about. The 30-day waiting period provision he supported did not ultimately become part of the law. And obviously, it's not the law today. Instead, the NLRB adopted a practice of a 25-day waiting period in almost every case. But this caution about the need for employees to have a chance to become familiar with the issues is just as true today. Employees who were not aware of the organizing activity at their work site, and even those who were, need to have an opportunity to learn about the union they may join. They'll want to research the union to ensure it has no signs of corruption. They'll want to know how other work sites have fared with this union and whether they can believe the promises the union organizers may be extending. Employees should have every chance to understand the impact of unionization. For example, they will no longer be able to negotiate a raise individually with their employer. Doing your job better than fellow employees may no longer bring any benefit whatsoever. Union rules may even hinder sales. Once had the opportunity to visit a shoe factory. I was in the retail shoe business, and we visited a shoe factory, and as we went through it, I saw some of the boxes of some of the shoes that we normally carry and was kind of interested in what the new fashion looked like, so I went over and I opened a box, and the roof caved in. Not really, but it seemed like the roof caved in because it has to be somebody that has union authority to be able to open that box, and it can't be the supervisor. So I actually shut down the factory for about 30 minutes just by picking up a box to look at what the shoes were in there that were probably going to be coming to my store at one point in time. Grievances cannot be brought straight to the employer, but they'll instead have to go through the filter of union management. Once a union is certified, the National Labor Relations Board has instituted significant restrictions for when it may be decertified. In other words, when the employees can fire a union as their representative. Employees are barred from petitioning for decertification for a full year after the election, and barred as well throughout the term of the collective bargaining agreement. So there really is a very small window in which employees have any opportunity to get rid of a union they do not support. They're going to be rushed into the judgment and then stuck with it. 4 decades ago, senators recognized that employees deserve the opportunity to gather this and all other relevant information before casting their vote. Unfortunately, the NLRB is choosing to ignore this caution, and rank-and-file employees will suffer. Fairness to the employee? This situation is exactly what the Congressional Review Act was intended for. When an agency takes regulatory action that's not supported by the people and their representatives, the Congressional Review Act gives Congress the chance to repeal that regulation. In this case, those advocating this are doing so because they cannot pass the bill they really want, which is card check. Now, card check is where you just have to have the people go in and stand over somebody's shoulder while they check a box that says they want to be in a union, and then with enough signatures or enough boxes checked, there is no secret ballot election. Many have referred to this as a backdoor card check. This particular NLRB regulation is a backdoor card check, and for good reason. Both proposals seek to restrict all communication with employees prior to a union election for union organizers only. Under both scenarios, employees are likely to hear only one side of the story, and employers can be cut out of the process altogether. But the other side cannot pass card check because once the American public found out about what they were trying to do, they objected. It took a little while because the card check legislation was deceptively named the Employee Free Choice Act, when in reality it would have forced employees into the exact opposite of a free choice. Any senator who opposes card check should also be voting for this resolution to stop ambush elections. Another reason the Congressional Review Act was designed for just this situation is that there is simply no other way we would be allowed to have a vote on this issue in the Senate. Back in December, the House of Representatives passed Chairman Klein's legislation that would have effectively killed the ambush election regulation and codify a 35-day waiting period before an election. The Workforce Democracy and Fairness Act was passed with bipartisan support, but it has no chance of being called up for a vote here in the Senate. So this vote is the one chance senators will have to stand up for employees and small businesses that want fairness. With any measure, the current law and certification system provides that fairness. The National Labor Relations Board keeps data on elections, timing, and sets up annual targets to process elections and decide complaints swiftly. Last year, they exceeded 2 of those targets and came within 0.3 of a percentage point to meeting the third. There is simply no justification for this regulation. Last year, initial elections in union representation elections were conducted on a median of 38 days after the filing of the petition. Almost 92% of all initial elections were conducted within 56 days of the filing of the petition. Not only are the vast majority of elections occurring in a timely fashion, but unions are winning more than ever. Unions win more than 71% of elections, their highest win rate on record. The current system does not disadvantage labor unions at all, but it does ensure that employees whose right it is to make the decision of whether or not to form a union have a full opportunity to hear from both sides about the ramifications of that decision. This resolution will preserve the fairness and swift resolution of claims which occur under current law. It will not disadvantage unions or roll back any rights. Let me repeat that. This resolution will not disadvantage unions or roll back any rights. What it will do is prevent the small business employers out in America from being ambushed and employees from being misled with insufficient information into union contracts that they cannot get out of. Under a successful Congressional Review Act disapproval, the agency in question is prohibited from issuing any substantially similar regulation. That means the National Labor Relations Board could not just reissue this regulation and could not finalize many of the other bad ideas they initially proposed. I will be speaking about some of those later on in this debate. Let's not wait for the courts to strike down this rule as they have the other NLRB's regulatory effort. That would be 2 out of 3 in the last 75 years. Now, with the President's appointment of the National Labor Relations Board, when we really weren't in a Senate recess, the Senate didn't confirm the people pushing this, that were pushing this effort, but most of this was done under the previous people. So with the President's recess appointments in place, the Labor Relations Board is poised to push forward other bad ideas aimed at helping union bosses, not employees, not job creators. It's time to stop this agency and level the odds. I'm pleased to have 44 fellow senators co-sponsoring the resolution, and I will now yield time to other members who would like to speak in favor of it, first allowing the senator from Iowa, the chairman of the committee, an opportunity probably to speak against it.